our community and some of the unique aspects that we have to face here in Arizona in trying to address that problem with local law enforcement in the context of what's happening with drug policy at the national level, and of course the continuing issues we have with the federal government not doing all that it should do, and I would argue is required to do under our Constitution. In particular, the availability of heroin within Arizona and the United States is underscored by going back roughly 4 years and looking at the amount of heroin that's been seized by Customs and Border Protection. All of this data comes from sector profiles released by Customs and Border Protection and their statistics. But in 2011, along the southwest border, so that's the entire southwest border from the San Diego sector all the way over to Brownsville, in 2011 there were 387 pounds of heroin seized, and that represented 97% of all heroin seized by the Border Patrol along the southwest border. In 2012, that number ticked up a bit, roughly 3% over the preceding year, to 399 pounds, representing 93% of all heroin seized. Then in 2013, there was a 40% increase over the preceding year, 44.4% increase over that first 2011 number, with 559 pounds of heroin seized, and that represented 97% of all heroin seized by Border Patrol. If you go to these specific statistics, it'll be listed in ounces, but for reference sake, I converted it to pounds for most people think in those terms. And in 2014, the amount of heroin seized was 575 pounds, and these are also fiscal years, I should underscore, and that represented 95% of all heroin seized by Border Patrol. And from 2011 at 387 pounds then to 2014 at 575 pounds, that represented a 49% increase over that time frame. That can be explained for a number of different reasons. But one other thing that I'll point out, and this was in the program last night, that law enforcement intelligence has been able to conclude that the Sinaloa cartel is actually shifting some of the land that they use to grow marijuana to actually grow poppies in order to produce heroin locally. That factor, along with their ability to distribute heroin within the Sinaloa cartel distribution network, and the amount that they're able to produce are the significant factors as to why it's available for such a cheap cost now as compared to what heroin used to cost in the past. And the other thing to underscore as well, and I think both DEA Special Agent in Charge Coleman referenced it during the program, and I think Surprise Police Chief Mike Frazier, who's also currently the head of the Arizona Association of Chiefs of Police, that for a number of youth and young adults who are becoming addicted to heroin, it's starting with an opiate addiction arising out of the abuse of prescription pain medication. That's one of the reasons why this office has partnered with other law enforcement agencies and community stakeholders in conducting so many prescription drug takebacks, as well as trying to educate and raise awareness among parents of the prevalence in which youth are getting prescription medication out of their parents' medicine cabinets, grandparents' medicine cabinets, the medicine cabinets of friends, parents, and grandparents. And then once they become addicted to that, then trying to purchase those similar drugs on the street, it can range anywhere from $35 to $95 a pill. When they no longer can get access to easy cash to do that, then we see other crimes related to their efforts to be able to get money to buy the pills, and that includes burglaries, selling stolen property, everything related to that. And once they are then in that state and learn that they can get a dose of heroin for as little as $5, well, it's a short trip to heroin addiction from there. Within this office, in taking a look at the impact of heroin on our caseloads, back in 2008, we had 280 cases in this office that were related to heroin. So that would encompass both possession use offenses, which are Prop 200 offenses. I'll speak more on that in just a moment. but that also then includes sale, trafficking, manufacture. That number jumped over 1,400 in 2014. That's a five-fold increase. And one area of the biggest increase we've seen in the last couple of years since 2012 has been cases involving the sale of heroin. In 2012, we had 27 cases. In 2014, and these are calendar years as opposed to the fiscal year stats I gave you on seizures. In 2014, we had 180 sale cases that we were prosecuting. Trafficking and transport cases, they're averaging in the 50s to 60s over the last several years. So that's, and then impact-wise, in 2013, I think 7.8% of all the drug cases that were handled by the office involved heroin. Last year, that jumped to 10.3%, and we'll have to see what happens this year if that trend continues. Hopefully it won't, based upon raising education and awareness, particularly among youth who might be vulnerable to using heroin in the first instance, a highly addictive drug. There is a physical addiction as well as a psychological addiction, which makes it so difficult to overcome. The Prop 200 aspect of heroin offenses, I want to raise that point because I think that when we look at the impact of heroin on individuals, families, and the community, it's also an opportunity to talk about responsible drug policy overall. I think you've heard me say in the past that I won't use the phrase drug war. It's not a war. Wars at some point have a conclusion. Even the 100 Years' War ended at some point. There is no end to trying to educate people and keep them from choosing to abuse a substance that is going to ruin their lives. It's an ongoing effort because people will always try to sell a product that they know will get them a continuing customer and someone who will do almost anything to get it. So in reference to a responsible drug policy, there are several phases that deserve national attention and a consistent effort. The first, of course, is prevention through education and awareness in order to limit demand. And last night's program was a perfect example of a concerted effort to do that. That's fundamentally the first thing that needs to happen in order to try to limit the number of potential customers for that product in the first place. The second component of that is also trying to reduce supply, and then a third component is trying to disrupt distribution networks. The other aspect, though, and this is where our Prop 200 approach factors in, is that in prevention, there is a role for the criminal justice system to have a coercive role in helping people break that addiction. And for Prop 200 and the diversion programs that county attorneys in this state run, focuses on initially diversion, which allows people, if they're able to successfully complete their substance abuse treatment, to avoid a criminal conviction. So even though in many of these instances someone might be facing a felony, if they're able to successfully complete that substance abuse treatment, which necessarily includes instances in which someone may relapse, that is part of recovery, and it's recognized, and law enforcement and prosecutors recognize that too. So if they successfully complete that diversion program, they're not going to have a felony conviction. We won't move forward with the prosecution. Even if someone then has that first felony conviction, though, because they failed and failed again, the second time that they're facing a Prop 200 offense, it's mandatory substance abuse treatment again. And just as in the first offense, they cannot go to prison. It is prohibited under ARS 13-90101. That was a voter-approved initiative. And in that second instance, due to a legislative change from a couple of years ago that prosecutors sought, I have the authority to offer diversion or deferred prosecution again And going through that treatment program with the coercive role of the criminal justice system at play too, someone can avoid a second felony conviction if they're able to successfully complete that treatment. And again, going through that treatment, there may be relapses because it's part of the recovery process. It's only when someone is then charged with a third or subsequent offense, or there's a violent criminal conviction involved, would they even then be eligible for incarceration in the Department of Corrections. So if you count up all those different opportunities and chances at trying to deal with the substance abuse issue an individual might have, they've received 1, 2, 3, maybe as many as 4 different opportunities to try to avoid incarceration for that. But as I've heard from family members, sometimes it's having that judge with the authority to sentence someone to jail or prison or mandate that they go through treatment, that someone really understands that they've hit rock bottom and are then motivated to overcome that addiction. So that's that one role there. And then when it comes to trying to reduce the supply, it is a continuing game of the next advance in technology utilized at border checkpoints and border crossings to try to identify when drugs are being smuggled into the United States, and then the cartels trying to circumvent that and overcome the latest technology to identify what they're trying to smuggle. And it's an effort that we have to continue. But we also have the problem here in Arizona of drugs being smuggled into the United States in between official crossing sites. And it's worth the federal government doing all that they're supposed to do to squeeze down those avenues of smuggling into the United States because of its impact to us here in Maricopa County and obviously throughout the country. And then the third, disrupting distribution networks. Law enforcement within Maricopa County, federal, state, and local are partnering and working together all the time. We have one of the best HIDTA relationships in the country. We're designated a high-intensity drug trafficking area. And the way that local, state, and federal partners come together, law enforcement, investigators, and prosecutors, to try to work on these issues, it's unparalleled cooperation anywhere else in the country. And that effort's going to have to continue while we work on those 2 areas. It will take a consistent effort over time as reflective of a responsible drug policy, looking at prevention, education, awareness, substance abuse treatment, and then to limit supply and to stay focused on disrupting distribution networks to be successful as we can be. So, next, some updates for you in appellate proceedings in 2 federal cases and 1 state case. We have asked the Ninth Circuit to review the Prop 100 case. We filed that petition this week. And I'll just say that the main point in that is that the Ninth Circuit misread the applicable case law. And if that ruling there were to hold in a number of other circuits, there are about 40 other states who have categorical denials of bail for certain types of offenses and or defendants that would be impacted. Second is the Puente case involving identity theft enforcement. We filed a petition for review, or filing a petition for review in that matter, and we're working on what that's going to look like and continuing to brief other county partners to determine whether they want to join in that effort. There is an important argument to be made with respect to field and conflict preemption versus the inherent authority of states from the founding of our country and the exercise of the police power. So it's not a simple 10th Amendment or policy argument. This is something that I think requires further review by appellate courts in order to determine, in instances in which courts acknowledge there's been no express preemption, whether or not a court can then find through implied preemption, whether conflict or um, field preemption, that states cannot act where they otherwise have the authority. And the 10th Amendment is designed to secure the responsibility and inherent ability of states to exercise their police power. And then third, we have filed a simultaneous petition for stay and a petition to the Arizona Supreme Court to review the dismissal in the State v. Milky matter. And it's simply seeking a fair review of the facts as set forth in the actual and complete trial record. And those are the particular cases and information I wanted to share with you this morning. What questions do you have?
In the Arias matter, there indications that officers were not truthful on the witness stand, but evidence may have been withheld, allegations of prosecutorial misconduct. Any comment on the handling of the case and any second thoughts about going forward with this second trial?
I'd say it sounds like defense play number 4, and I won't make any further comment given the court's order in that case.
No second thoughts about doing this a second time?
I really don't want to comment any further on that, Mike. I'm going to let the court process take its route.
Is there anything more you can talk about as far as the arrest made in the cold cases from the early 90s, very high-profile cases at the time? The police work involved or your office's involvement as we go forward? Anything you can talk about?
I really want to give Phoenix Police Department the opportunity to cover that in detail. They did just such great work here, and there was a partnership with my office at different points related to some investigative decisions. But what they were able to do in this particular case is really phenomenal, and I'd like them to get all the credit for it. We're going to benefit from it as prosecutors because of the degree of work that they did in moving forward. And there's been an arrest made. Nothing's been submitted to my office yet, but we've been in contact leading up to this arrest. I think certainly the people of Phoenix can be very proud of their police department here.
Generally speaking, and you've talked about this before, though, with cold cases, what message does this send to people who committed crimes even 20, 25, 30 years ago and more that they think they get away with it?
Yeah, well, I think what this underscores, as I've referenced in the past too, is that ever-increasing developments and improvements in forensic technology and scientific methods are allowing us to utilize evidence that was initially secured at a crime scene in ways that no one even imagined at that point in time, least of all the perpetrator. And going forward, I think what this also does is underscore the point that law enforcement really never gives up where there is a chance at trying to identify who may be responsible for a criminal act. And in the instance of homicides, where there is no statute of limitations, and the loss of life and its impact to families and communities can never really be measured, that continuing commitment to trying to solve these cases and then taking advantage of the latest developments in science continues to give us the opportunity to bring people to justice who otherwise thought they might have escaped it.
Was your office where how the undercover officer got the DNA samples, and was your office consulted on the legalities?
Those are questions that I'm going to refer to the Phoenix Police Department.
And how difficult will the case be to prosecute, knowing that they say they received thousands of leads over 20 years?
Well, obviously easier now that we have a suspect.
Any movement on the officer involved shooting from the risk of the case?
That's still under investigation, and nothing's yet been submitted to the office for review, Mike.
Are you ever going to indict the Jose Baca, the guy who embezzled $886,000 from the state superintendent of schools?
Depends on when we get a submittal. Yeah, we have 7 years.
What about how much money is being spilled on areas?
Again, that's something particular to the case, and I'm going to abide by the court's order. Any other questions?
The matter get lots of heat on social media, and your office has been criticized for its handling. Anything you can tell us about that?
Well, Mike, I would just note that in that particular case, as we've gone along, I've met with concerned families. I've met with the attorney, spoken to him several times, and in trying to understand the almost myopic focus on just one set of defendants, the only point I can now conclude after seeing everything that has been presented to the media and the use of social media, and in some instances, best case mischaracterizing or misunderstanding, worst case outright misleading the media, is that this is just an effort to further their civil suit and identify deep pockets. It's absolutely nothing that is assisting with a criminal review or the criminal prosecution. In fact, in some cases, it could hinder the criminal prosecution. And, I say that for really three specific reasons. One is that almost myopic focus on one set of defendants. When we've got two set of defendants and the relative differences in relationships between the defendants and the families and the dog owners involved is very distinct and different. So I think, but for somebody's last name, the hype and the hysteria wouldn't exist. The second point would be, even after briefing folks and answering every question and addressing every concern, falling back on trite accusations of what's motivating this office's decisions. I don't think anybody could fairly or sincerely question my commitment to the rights of victims of crime, or how this office has approached criminal cases and making decisions involving the criminal justice system is focused on what the law is and the evidence. From day one, when I took office here, particularly in light of what had occurred in the preceding several years. Yet, even after sharing all that information and spending all that time, to have people go out and take to social media and continue to say the same thing, or in the instance of the attorney, spending 45 minutes and reviewing procedural steps, the decision to dismiss counts when faced with a motion to remand that was going to be granted. And nothing has occurred procedurally in this case that I didn't talk to the families about ahead of time and went over with them about possibilities. And then when motions were filed, sharing what I thought the impact was going to be with the attorney and the likely outcome, only to have him then turn around and on camera say he didn't understand the decision. So either he lied when he told me he understood and didn't have any other questions or concerns, or he forgot in just a few hours. Or, as I started to mention, it helps posture the civil case better to criticize the criminal case or try to force the criminal case in a particular direction. And it works this way. Under Arizona law, each necessary element that makes up a criminal conviction is deemed admitted in any subsequent civil case. So the demand to have certain people prosecuted and convicted would further seeking a civil judgment in any subsequent civil case. And I've been painstaking in my sharing of the analysis of evidence and what we had to deal with. And yet again, still to turn around and say that they didn't understand, and then parading children in front of cameras with framed pictures of their pets. I don't see that in gruesome criminal cases. So again, the only thing I can factor in is that it's to further heighten their civil case. And the last point, and what occurred on Friday, I'd communicated at the outset my willingness to meet with the concerned families, and that those meetings were private, and I wouldn't share the information with anybody outside of that meeting, and only to have them turn around and do that on social media. And then on Friday, to communicate and encourage demonstrations and people to show up in advance of that meeting, at the same time that I received an email at 9 in the morning purporting to have been written by a 13-year-old special needs child, and the verbiage in it, I question whether or not he really wrote it or somebody else wrote it for him. Only then, within an hour, to see that same letter posted on Facebook and then tweeted out for everybody else's consumption. It was at that point that I made the decision that I was going to cancel the meeting. I'm not going to permit the criminal justice system to further somebody's civil case, and I'm not going to contribute to the kind of hysteria and really what I think is irresponsible conduct by the attorney in question and some of the things that he has said. He certainly has the First Amendment right to do so, but that First Amendment right also comes with a responsibility. And again, mischaracterizing and misleading what my communication was to him. I told him specifically that the meeting that had been scheduled was canceled, and it was a private meeting for the concerned families to give them the opportunity to ask questions and follow up on the 45-minute meeting that I had had with him. And I felt that given their efforts to publicize the meeting, the use of the letter that at least seemed to me was supposed to be a letter to me for my private consideration, led me to believe that in light of, in particular, the ethical rules that I read you this morning, there were people who were associated with the case that were making extrajudicial statements and would likely use whatever information I shared with them to further those statements, to further their posturing, and my belief, further their civil cause, was something that I couldn't participate in or be a part of. And I won't going forward either. We will certainly abide by their constitutional rights as victims of crime and do everything that we're required to do. But I will not extend any courtesies whatsoever. And if we were faced with a similar situation in other cases, I'd be driven to the same conclusion too. I was willing to try to reschedule a meeting in the future, but it's my understanding that I want to reschedule, and that's fine. It just eliminates another opportunity to misrepresent what this office is doing anyhow.
Is there still the potential that you go back to the grand jury in this matter and now concluded that?
No, there's still the potential. We're still reviewing the information that was called into question through the defense motions. And look, the bottom line is this. When I, as a prosecutor, or any of my prosecutors, are faced with a challenge to grand jury proceedings, and objectively we can see, yeah, you know what, there was more information we should have presented. And to underscore the point, I don't think anything intentional happened. I think there was a particular theory of the case, and that's what was being presented to the grand jury. There's an alternative theory that could and should have been presented. If we had waited for that motion to be heard by the court and then granted, we would have had 15 days to represent it to a grand jury, or those charges would have automatically been dismissed without prejudice. I knew then that it was going to take us more than 15 days to do all that we need to do. So rather than wait for a court to tell us what to do, because we already knew it, we took the steps we took. And we're continuing now to review all the evidence and the information in question. We have to be able to account for the reduction in electrical usage. That's a question a future juror might have sitting in the jury box. Rather than wait for that point in time to try to theorize what it might be, we have an obligation to try to determine what that is now, because that's going to factor into the analysis. And that evidence could play differently between two different sets of defendants, given their relative roles and what happened and their relationship with the dog owners. It's not a complex obligation here, and it's not a complex decision. It's rather straightforward and rather easy for us to make if our goal is to ensure that we arrive at a just result. If my goal was to pander to a particular group of people or pander to a particular group of victims, it would be very easy to sit back and let a court tell us what to do. And before that 15 days had expired, to go back to the grand jury with the case in its current posture and simply throw it out there and let them return a no true bill, and then turn to the victims and say, see, we did everything that we could. But that's not just either.
The state Supreme Court heard a case yesterday about people who are on parole and probation and the right to medical marijuana in the state. I just want to first get your thoughts on that, and then also touch on, is there any difficulty that you face as a Maricopa County attorney in terms of one of the state's arguments is that there's a discord between federal recognition of medical marijuana in the states and what kind of problems that might cause for you as a Maricopa County attorney?
Well, it's been causing me problems ever since it was passed. But to the first point, the case itself, typically in any case in which it's resolved via plea agreement, the parties can agree to just about any set of conditions, to include stipulating the particular conditions of probation. And so that's sort of the first point. But in terms of somebody having a right to use marijuana, again, now that starts to implicate some of the problems that we have with the conflict between state law on marijuana and then federal law under the Controlled Substances Act. And that's something that has to get resolved. In general, terms of probation require you to follow the law. And if we're dealing with someone who has substance abuse issues, stereotypically, even if it's a DUI, there's a prohibition against using alcohol or any other drugs. Now, the only exception to that might be something that you could be prescribed, but you can't be prescribed marijuana. It's a recommendation. So, that's another aspect of this that makes it somewhat different than similar circumstances with defendants involved in being supervised for probation. So that's sort of some background on that. But in terms of the conflict itself, yeah, it's a huge conflict. My oath of office and that of anybody else who has to take an oath of office to serve in a position of trust and responsibility in the state of Arizona takes an oath that requires us to uphold the U.S. Constitution and the Constitution and laws of the state of Arizona. And even in the matter that we're litigating before the Court of Appeals, out of this office, the trial court recognized that there's a conflict. And this is one particular area where the way that this is set up, just in case anybody's waiting to ask the question, the way that this is set up, this is different than the argument we're making about conflict and field preemption versus express preemption and the supremacy clause in the 10th Amendment. Where the federal government is acting with specific powers that have been allocated to them under the Constitution, the supremacy clause is pretty darn clear. So trying to carve something out in that regard where a state is affirmatively allowing people to violate federal law, that doesn't pass a straight-faced argument with respect to the 10th Amendment. So as much as I believe in that, I think I'm being much more faithful to the Constitution when I acknowledge there are areas where states can't act as much as I am and insisting upon a state being allowed to act where it has the authority to.
So when it comes to your oath and your duty to the federal government and the Constitution versus the state, I mean, is it, if that's what you mean by supremacy, you would have to decide a bit?
There's no loyalty to the federal government per se. It's loyalty to my oath as the Maricopa County attorney and my duties and responsibilities in carrying out that oath that I can't advocate for violating federal law at the same time that I'm trying to uphold state law. And in this particular instance, the Medical Marijuana Act created specific exemptions from state prosecution. States can do that. States don't have to pass laws that mirror federal laws when it comes to criminal statutes and enforcement. In fact, there is Supreme Court case law on that. The federal government cannot co-opt officers of the executive branch at the state level to enforce what the federal government wants enforced. But what we can't do, this is my argument, is that we can't set up a system in which we are affirmatively authorizing and facilitating the violation of federal law. So does that help clear that up? Any other questions? Okay, thank you. Look forward to the next year.